So why will the Service Convention in fact be beneficial for Singapore? As a starting point, Singapore litigants are currently able to effect service of documents overseas, even without the Service Convention. If the requisite approval of the Singapore court is obtained to serve a court document overseas, service may then be effected overseas through the various ways set out under the Singapore Rules of Court, specifically Order 8.2. That said, a litigant seeking service abroad will likely encounter legal uncertainty on multiple fronts. I will give 3 examples. First, there is uncertainty over the permissible channels and methods for effective service in the destination country. Which channels and methods for service of foreign process are available for a particular country can vary quite a lot. Getting it right is important as it can affect the validity of service and the subsequent recognition and enforcement of the ensuing judgment. Second, there is uncertainty over the accompanying requirements and formalities. Again, different countries have different requirements. In the incoming requests that I have seen at the Ministry of Law, many have to be returned due to missing translations, missing information, among other non-compliances. And a perhaps more fundamental uncertainty, in the absence of a formal agreement, there is, strictly speaking, no obligation on the requested foreign authority to give assistance or even to respond. Adding to this uncertainty is the lengthy process of transmission through government-to-government channels. As provided by the Singapore Rules of Court, the Supreme Court Registry will forward the request to the Ministry of Foreign Affairs, who will then send it on to their foreign counterpart. It is typically then sent to the competent foreign authority, who then causes it to be executed on the addressee. And at every step in this process, there is the risk of a delay. We expect the Service Convention to help address these challenges. One clear improvement is that government channels are streamlined under the Service Convention, as Melissa explained just now, with the use of clearly designated central authorities. The number of layers a document must pass through to be served is therefore flattened. With the Service Convention, we expect that disputing parties will have significantly more legal uncertainty. So it will be easier to find out what channels a contracting party permits or does not permit. These are set out clearly in the convention, read with any applicable declarations by the relevant destination state. And the HCCH website is indeed extremely useful in that regard. There will be more certainty, it will be more easily ascertainable as to what requirements must be complied with and what information provided. And there is clear assurance that the request will be acted on. There will be clarity and uniformity as to when a request may or may not be refused. So to be clear, the expectation is not that the Service Convention, immensely useful though it may be, will magically remove all ambiguity and uncertainty in the process. And I believe the discussion later on will give a sense of this. Further, the dispute resolution landscape is constantly changing, and inevitably questions will arise and have arisen as to how the convention will apply to scenarios that may not have been around or significant before. So one thing I very much appreciate about the practice of the HCCH is the follow-through and the continued work even after the adoption of the convention. The Permanent Bureau actively monitors state practice, raises issues that affect the operation of the convention, and makes recommendations to contracting parties. And this was well demonstrated and referenced by Melissa's presentation earlier. The work of the Permanent Bureau feeds into the work of special commissions of states, which are regularly convened by the HCCH to review the practical operation of the convention and ensure that the convention will remain fit for purpose, whether in 1965, in 2023, or beyond.